Hello, 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 hello. Thank you all so much for coming this evening. I am Julie Kalish. I am doing these intros, and then I'm going to sit down and listen. Thank you for coming this evening to what I know already is going to be a really fascinating conversation. Thank you in advance to our speakers and to our moderators for having that fascinating conversation. The event tonight is taking place thanks to the Rockefeller Center and Dartmouth Dialogues. It is also taking place due to the amazing work of Devorah Greenberg-Kohling and Madison Peel. They are the ones who make all of these events transform from ideas into actual events. So thank you to everybody. The conversation you're about to hear is part of the 2024 election speaker series that is itself part of a fall government and public policy class entitled the 2024 election. The talk itself has been titled The Supreme Court and the Future of American Democracy. So it's a weighty title and a very weighty topic, one for which we're going to need a good deal of time. So forgive me if my introductions are designed to save us some time. Our two moderators this evening are Professor Herschel Nachlis and Professor Sonu Bedi. Both of them have titles that are entirely too long. If you're interested in those, I have them here in footnotes. But for our purposes, just know that they are two very beloved government and public policy faculty members whose courses on law, the courts, and politics are must-takes amongst our students, particularly those who are interested in law. Professor Nachlis actually is also co-teaching the elections course, so that is responsible for bringing all of these amazing people to campus, so thank you for sort of letting us take your class. Professor Nachlis and Professor Bedi, they will be speaking tonight with Professors Jeannie Suk Gersen and Keith Whittington from Harvard and Yale Law Schools, respectively. There will be a lot of ivy up here on the podium. Professor Jeannie Suk Gersen is the John H. Watson Jr. Professor of Law at Harvard Law School, where, among other things, she teaches courses on constitutional law, criminal law and procedure, discrimination, and sexual assault and harassment. Professor Gersen earned her undergraduate degree from Yale University. She was a Marshall Scholar at Oxford studying French literature, so students, please take note. There are many paths to law school. There are also many paths not to law school. She earned her law degree at Harvard and went on to clerk for both Judge Harry Edwards of the U.S. Court of Appeals for the D.C. Circuit and for Justice David Souter of the United States Supreme Court. Gersen served as an assistant DA with the Manhattan District Attorney's Office before returning to Harvard in 2006 as a faculty member. Professor Gersen has written 3 books, many scholarly and popular articles. She has received numerous awards, including a Guggenheim Fellowship. She is a contributing writer and legal correspondent for The New Yorker, covering the Supreme Court. When she was last here at Dartmouth, she was sharing her thoughts on the then recent overturning of race-based affirmative action, and we look forward to hearing her thoughts about the future of the Supreme Court and democracy, so no pressure. She handled a lot of pressure very well on the other topics, so I'm not worried. Keith Whittington is the David Boies Professor of Law at Yale Law School. His teaching and scholarship spans American constitutional theory, political and constitutional history, judicial politics, the presidency, free speech, and the law. His most recent book, one in 2024, is called You Can't Teach That: The Battle Over University Classrooms. He has also written books on judicial review, constitutional interpretation, the importance of free speech at colleges and universities, and the political foundations of judicial supremacy. If that sounds a little too overwhelming, you can also find writing from him in the Wall Street Journal, Washington Post, and New York Times, among many other publications. And for the podcast crowd, he hosts the Academic Freedom podcast, available wherever you get your podcasts. Professor Whittington has spent most of his career at Princeton and has held many prestigious fellowships. He currently serves as the founding chair of the Academic Freedom Alliance's Academic Committee and as a Hoover Institution visiting fellow. As pertains to our topic tonight specifically, I just wanted to highlight that Professor Whittington served on the Presidential Commission on the Supreme Court of the United States. This was a commission established by President Biden in 2021 to, among other things, quote, provide an analysis of the principal arguments for and against proposals to reform the Supreme Court. So with that, I will sit down and I will let them talk. Thank you.
You guys grab the middle. So we've got a lot of questions, not a ton of time, but before we get started, just wanted to thank you both for coming back to Hanover. It's really an honor. And we should start off with the issue that everybody is on the edge of their seat to hear about, which is administrative law and the administrative state. So during the Biden administration, a 6-3 conservative supermajority overturned Chevron, worked to reduce the power of agencies that implement policies with things like the major questions doctrine, the non-delegation doctrine. But at the same time, the court increased presidential power through other decisions. And so do these court decisions during the Biden administration, weakening the administrative state while increasing the power of the presidency, enable the Trump administration, constrain the Trump administration? How does this net out? Now? Jeannie, why don't we start with you?
Okay. Yeah, so I taught some of these cases a few weeks ago, and there definitely was a feeling of, oh, these are so horrible. How could the court do this? Well, after the events of last week, when we now know that the president and the executive agencies that he will control will be trying to do things that are different from, say, the Biden administration, I found that some of my students changed their tune on some of these cases, because in effect, the case that was overruling Chevron, basically saying you no longer, as a judge, you no longer have to defer to the agency as long as they have a reasonable interpretation of a congressional statute. Basically, you don't have to defer anymore, and so what that means is that whoever was the president and whoever was in charge, whether it was a Democratic administration or a Republican administration, that meant that judges would have more power to strike down things that the administration is doing. So what that means now is that if you think that the policies that the Trump administration is going to be trying to put forward are ones that you would like some other parties to look really carefully into to make sure that they follow what Congress said, then you should be actually feeling awfully good about the Loper-Bright decision that maybe a few weeks ago you would have thought, oh no, this is going to destroy the administrative state and make it really impossible for the administrative state to get stuff done that I want to be done. So I think that's a flip that I think that we need to take on board. I think same thing with the major questions doctrine, the idea that if it's a major question, then Congress has to have spoken very clearly on the matter for administrative agencies to have authority to act in that ambitious, big way. Well, again, like that doctrine, which you might have thought, oh, makes it harder for, say, the EPA to get something done. Well, it also now is going to make it harder for Trump's EPA to do things and more scrutiny of those decisions. So I think a lot of these are double-edged decisions, and when we see them only with the assumption that the party in power in the executive branch is our party, it looks utterly different than when you think of them as cases that constrain executive branch power, which is what these things are. And even the Trump immunity decision, on one hand, one side of the double-edged sword is it gives the president a lot of power to know that he has immunity from prosecution for official acts. Sure, that's going to have some consequences. But on the other hand, it also means that Biden, Obama, Clinton, other former presidents who are alive, who, maybe the Trump administration's DOJ might think, hey, maybe it would be good to prosecute these people for things that they did, and don't give me, oh, but they didn't do anything wrong. So there are things that they could totally be prosecuted for, which they will not be as a result of this decision.
Keith?
Yeah, no, I think that's right on both fronts, and certainly I think one thing that's always been a little odd about Chevron deference as it had been put in place by the courts is it created a great deal of deference by courts to legal interpretations of administrative actors, often interpreting the scope of their own power. And so this, in effect, creates somewhat greater judicial checks on the administrative state and what it does. And that's going to have implications for the Trump administration and make it harder for them to pursue some of the policy agenda they might otherwise pursue. I think one of the longer-term challenges posed by this at the same time, however, is it's still the case that Congress seems pretty incapable of doing a lot of legislating. And that does create a difficult situation in which you have old statutes that have not really been written with some current public policy problems in mind. Courts are going to construe those statutes, I think, somewhat more narrowly than the executive branch might have been inclined to do so, and that's going to make it tougher for the executive branch to unilaterally address some public policy things we might want addressed. And it's not clear Congress is going to step up to the plate, though, and help out by actually doing their job of legislating new public policy solutions and empowering the executive branch in various ways. And so you would like to see this married with greater legislative activity on the part of Congress, but I'm not sure we're going to see that.
Good, yeah, and so one thing that's nice, first of all, it's really nice. We have like such a great group here, and what is hope that folks can see is that there's a way to talk about the court that's non-ideological, that you can focus in either from Democrats or Republicans and see from both sides that, okay, there may be some switching that has to happen so that we're looking at it from both. And so I want to pick up on that and wondering about the composition of the Supreme Court moving forward, right? I know that Herschel was talking about some recent decisions, and the other thing we can look at is who could join the court. And so given that Justice Ginsburg didn't step down, right, during the Obama administration, it would have allowed Obama to appoint, to replace her, and she passed during the Trump administration, was replaced by Justice Barrett. And so liberals have been saying that Justice Sotomayor, she's the oldest member, liberal member of the court, that she should retire while Biden is still president, so he has time to appoint her replacement. And on the other side, because again, it's important to look at it from Democrat and Republican, on the other side, Justice Thomas is 76. Some folks say that he should resign early in the Trump administration so that Trump can replace him with a solid conservative. And so the question is, how do you respond to these arguments on both sides? And Jeannie, you clerked at the Supreme Court. Why don't you start us off?
Well, I clerked for a justice who retired at the age of 69. He was fully like functioning and like vigorous. Like there was no issue of his having slowed down. He retired because, as he told all of us, he wanted to be a person who wasn't only a Supreme Court justice. He wanted to have, he wanted to return to who he was as David Souter, not as like Justice David Souter. And he knew that he could have another really nice chapter of his life, not in Washington, D.C. Now, I do think that that has proven to be a bit of an unusual attitude that judges and justices take toward their jobs, because I do think to be in one of these jobs, like, this is a job with life tenure. You can stay there as long as you want. And we don't have that for the presidency. We don't have that for members of Congress. No other branch has that. But I think that that also means that it's a job that's really hard to give up, because your identity becomes so embedded in what it means to be a justice, and it's very hard to separate out those two identities. So in terms of these other justices who are now like being pressured or have been pressured to resign, we know that Justice Breyer, stepped down. We know that Ginsburg did not. We know that Souter did. I think that I would not expect Thomas or Alito to step down anytime soon. That would be my prediction. I think today it was reported that Alito said he would not step down. I mean, in the foreseeable future, that could change in a couple of years. But I do think that it's just very, very hard for justices, especially like when they're being nominated and confirmed, they're supposed to deny that they are partisan actors. They're supposed to be like, this is my judicial temperament, I look at cases fairly, I don't think of it in terms of like, is this helping the Democrats or is this helping the Republicans? That's what they need to do to get confirmed, to really embody that. And a lot of them really do sincerely believe it. The justices, like their internal state is not, oh, I just really vote with my party and then just try to put some nice legal language over it to make it seem like it's nonpartisan. That's not how they experience what they're doing. They think of it as nonpartisan, as totally legal. And so once you've kind of acclimated people to think of themselves that way, then to ask them like, you better resign because this party is not going to be in power for much longer, so you need to be replaced by another basically party hack or something, that's really not consistent with their identity as justices. So I think that's a pretty tough sell.
Keith, what do you say to that?
Yeah, I mean, I think partially we have seen a change in the nature of the kinds of people who are appointed to the court, and there are a variety of reasons, I think, why we've seen this transformation. But we're now in a position where the kinds of people we appoint to the court are people who, throughout their careers, have wanted to be Supreme Court justices. This is the realization of their lifelong ambitions. That was not true of a lot of earlier Supreme Court justices, where that was not their lifelong ambition, and often they're kind of bored on the court, and they'd rather be doing something else. Including potentially even private practice and making money again. But that's not true of these justices. These justices wanted to be on the court their entire lives. They were scrambling to try to get there. Justice Souter, I think, was sort of the last example of a justice who was not living his life in order to be a Supreme Court justice, and so it's not surprising. I think he stepped away from it in ways that a lot of the other justices simply don't. And it's also the case that being a justice is a pretty cushy gig, and so it's a lot like being a law professor. You get nice summer vacations. You have all these youngsters who do a lot of the work for you, and so it's pretty easy to be quite old and decrepit and still do the job. And so there's not a lot of incentive then to step away under current circumstances. And so justices, I think, tend to want to stick around. And even if they do have some real political sensibility about, for example, they don't want to leave the bench when somebody that they radically disagree with about the law is likely to be appointed to replace them. And it's not unreasonable for justices to have that consideration in the back of their mind as they're thinking about, when do I step away, for example. Is the person that's going to replace me going to undo my life's work on the bench, for example? Even with that kind of consideration, it's also easy for them to imagine, I'm irreplaceable, I can't possibly leave the job, and what else would I do with my life if I wasn't being a Supreme Court justice? And so they stick around.
Justices sounds like academics, right?
Justices are a lot like academics. Yeah, you don't see a lot of professors stepping down early either, actually. So, which would not have been true back in the day when they had to ride circuit and stagecoaches, right? Then justices were a little more inclined to say, I need to find a different career and let's leave. And so, if you made justice's life less pleasant, for example, they didn't have a discretionary docket. They actually had to take every case that came up to the court, and they had fewer clerks to work with. Some more of them may have decided, I'd rather be doing something else in my life rather than spending all my time deciding, all these cases I'm currently avoiding, and that the circuit court judges have to normally deal with.
I want to stick on the judicial personality theme with a very non-political science question, if that's all right. And so it's really a question about how judicial personality matters to performance. Just to illustrate this with one example, and you've both spent tons of time around all these folks, but about a decade ago, I sort of spent the day with Justice Alito, and this is before most people were paying attention to Justice Alito. And it struck me over the course of that day that this is somebody who just hates politics, hates Washington, D.C., and is frankly sort of an angry person, an angry political actor. And anybody who's read Dobbs, the decision that overturned Roe v. Wade can see this anger and this hate of DC politics sort of baked into the decision overturning Roe. And so political scientists kind of dismiss these personality factors. And I'm wondering how, whether Alito or some of the other justices, like how personality plays a role for these people who are, after all, human. Keith, you want to start us off here?
Well, political scientists ignore in part because personality is really hard to measure. So, but there's small N groups that are like the presidency in that regard, and that individuals matter, and individual choices matter, and so you can't just aggregate up the way you often do with Congress, for example, or certainly with voters, and think, oh well, the individual personalities just sort of wash themselves out, and we'll just pay attention to the large numbers. When you're talking about a small group like the Supreme Court justice or a single individual like a presidency, the individual character of the person exercising power makes a difference, potentially, and can matter. But it's, I think, also extremely hard to measure that very effectively and analyze it in very meaningful ways. Part of the way in which we do tend to play that out, I think, in the context of justices is less on this sort of personality dimension than in trying to think about what are the subtle differences in judicial philosophy between a Justice Barrett and a Justice Alito or a Justice Roberts, for example, and try to disentangle the individual differences out on that dimension rather than is that person particularly angry and or the like. But maybe there are features of that play a role that we ought to be taking into account. I'm a little skeptical, I guess, that there's a lot more there that we could successfully mine, but maybe. I mean, I do think that the sort of personality and anger issue, I think, is sort of one thing, and maybe that's sort of individualistic, and you can sort of set that aside. I think there is, though, another dimension that is quite relevant to the justices and generalizable beyond Alito and others. Is I think there's a lot of sort of distrust of the political branches that exist in the judiciary generally, and especially in the Supreme Court, that's relevant to questions about how much deference should we show to those other branches and the kind of decision making they're engaged in, for example. And if you don't trust that they're taking their constitutional and legal responsibilities very seriously, it certainly undermines your desire to be very deferential to the conclusions that they're going to reach on that front. And again, maybe it's connected to the fact these are sort of professional judges rather than people who spend a lot of time in the executive branch, for example, and they came up through other political venues, but I think they are much more judicial supremacist in that regard and less inclined to be as deferential to the decision-making capacity as well as the decision-making orientation of the other branches.
I am so not a political scientist, so I really adore this question
Great.
a lot. So let me start. Let's go back to Dobbs, since you also mentioned Dobbs. What was the thing about Dobbs that shocked everyone? It wasn't necessarily the result. I think we all knew what the result would be when we heard the oral argument and all the reporting around it. That was pretty clear. But what was shocking was that it leaked, and the reason that was shocking in this era, is that it had been like, I don't know, a good 40 years of the Supreme Court being the kind of institution that didn't leak. And that goes directly to the personality question, because it's about institutional norms and then selecting for personalities. Like all the law clerks had a certain stayed buttoned down. I'm part of this generation, like, buttoned down, like we really respect norms and rules, and you don't do weird stuff at the court. Whereas like now when I hear about the law clerks and what they're doing at the court in the off hours, I just think, oh my gosh, like
there's a lot of weird stuff going on there.
You know what I mean? Like, we would never, anyway. But so I just think with the change of generations, different personality types become like more like normal in a certain profession. So when you think about back in the old days, like, even think about like, Justice Douglas or Frankfurter or Justice Jackson. Like these are big personalities with lots of foibles, like, personal hatreds that were like out in the public often. They were constantly like calling reporters and, telling bad things about their colleagues to reporters. And it was like it was very much a war of personalities, not just a war of judicial philosophy or judicial ideology. Like it was like they had personal, real beefs with each other because they each were those kinds of, now, over time, I would say, like during the Rehnquist court, like the court selected for more of a button-down personality, and Scalia was what counted for like a big personality. But everyone else just, that became the judicial kind of personality, and it also trickled down in the legal profession. And most of my generation of people, like, who are now in their 50s, like we lived our lives, even if we didn't think we were going to be judges, we lived our lives as if we had to be confirmable in front of a Senate, right? That we did not assume was going to be overly partisan. We just thought like we'd get in trouble if we hired an illegal nanny or smoked pot or so like a lot of the lawyers my age have never done any illegal drugs, right? So basically we lived our lives that way. That's going to affect the personalities that select into these jobs. But at one time, the legal profession had room for these much bigger personalities. And I don't know what the future holds. And in terms of the justices, you're right, that Alito, he's not a huge personality. And maybe what you sensed was anger. But at the same time, that anger is like, very, like you said simmering, right? It's simmering. It's not like exploding. And I think in another era, we would have seen much more of an expression of whatever personality traits were present in a justice.
Okay, good, good. So I'm going to move from sort of the personality, right, and the composition of the court to sort of focus on some substantive areas, right? And so let's talk about affirmative action on campus. Obviously, it's something that's relevant to this audience. So as we all know, the Supreme Court struck down affirmative action last year as an unconstitutional, as a violation of the Equal Protection Clause. So many schools, including Dartmouth, have admitted classes that demographically look pretty similar to how they looked when affirmative action was allowed. And so what do you make? Will lawsuits follow? How might that play out? And Jeannie and then Keith, yeah.
I think some lawsuits will follow, but I think at the schools that are like Dartmouth or Harvard or Yale or Duke, these schools have known that they're in the spotlight for years. So it's not like they were thinking, oh, we'll just see how it goes, and then if we get sued, whatever. No, they've been preparing for a possible lawsuit, which is why I do not think at these schools, I'm not talking about other schools, like these schools that know that they're in the spotlight, like you're not going to find like emails that are like, let's just circumvent what the Supreme Court said by, considering race anyway, but like hiding it. Like they're not going to find stuff like that, And also, when you say the demographics haven't changed as drastically as people represent, like the schools represented in court that they would, So that's the thing. Like if they say, if we don't use race in admissions, it'll be this horrible, drastic result. And then it doesn't happen. Yes, one accusation could be, oh, it must be that you're cheating, right? But that would be a dumb thing to do, to cheat, after the Supreme Court said that, right? And especially at these very sophisticated schools with, they're really thinking through what the legal ruling means. What they've done is instead of just like keeping their admission system exactly the same, except just taking out, consideration of a student's race, they haven't done that. Obviously, then maybe the numbers would have been different. They have changed other aspects of the system in order to promote the value of diversity on campus, diversity of all kinds. And the Supreme Court has been very clear for decades that if you are going for diversity, including racial diversity, but you're doing it in a way that is race neutral, like you're not considering each individual's race in considering their application, that's okay. So for example, like the famous example of the Texas 10% plan, which was you take the top 10% of every high school, and because there's racial segregation in where people live and where they go to high school, that meant that you were automatically going to have somewhat of a diverse class, because the top 10% of a majority black school and the top 10% of a majority white school or the top 10% of a majority Latino school, you would have that diversity. Now, is that a race-conscious measure? Well, on the one hand, you could be like, yeah, it was race-conscious in that they designed it so that they would produce racial diversity. But the Supreme Court is very clear that that kind of race consciousness is not unconstitutional. That what is unconstitutional is when you take an individual applicant and then say, this person is going to get fewer points or larger number of points because of their race. And that is what's not allowed. And there are many, many ways that schools are experimenting with and planning for, and long-term planning as well as short-term planning, about how to get diverse classes, because they know that that is a value that they're going to pursue. And they're going to try to do it within the bounds of what the Supreme Court said was allowed, and they're going to avoid the things that the Supreme Court said was not allowed. So sure, there will be lawsuits, and remains to be seen whether they will have much success, but I tend not to think that schools like Dartmouth and Harvard haven't thought that through, and I don't think you're going to find much there.
Keith, what do you make of?
No, I think all those things are true. I think it's clearly the case that universities, especially elite universities, understand they are under a microscope at this point, and they've been trying very hard to make themselves defensible against lawsuits, and I think at this point we should recognize as well against investigations from the executive branch, because I think there'll be those as well.
But hopefully there won't be an education department after
Yeah,
right?
so I believe there'll be investigations further. It's an end to the education department. So I think there'll be investigations. I think there'll be lawsuits. I would be surprised, I think, if they find much of a paper trail that demonstrates violations of the law, both because there's going to be a serious effort to not create paper trails, and also because there are lots of ways of manipulating the admissions process is consistent with the law, and schools have been very careful in trying to think that through in order to avoid it. I think it's probably the case that there are some less elite institutions that are not being as careful, and as a consequence are probably more vulnerable. I also suspect that if you get outside of the professional admissions office for undergraduate admissions and were to look at things like faculty hiring and graduate admissions, you'd find a lot more legal violations even at elite institutions. But those are also much harder lawsuits to bring. The case law about the governance of that is also much less clear. But it wouldn't shock me if we see a pivot away from undergraduate admissions lawsuits and increasingly focus on other things universities do where they might also be legally vulnerable.
Okay, good. Well, let me follow up on that and talk about, and Keith, you can start us off on this, on free speech on campus, or considering free speech, and about this issue of free speech in the incoming administration. So how will sort of like organs like the Office for Civil Rights at the Department of Justice, or the Office of Civil Rights at the Department of Education, assuming it's still there, engage with issues of speech on campus, right, related to gender, race, religion, politics, or otherwise? And so, yeah.
Well, I think it remains to be seen. I think there are real tensions among conservative activists, and I suspect between the kind of political appointees the Trump administration will put in place, between, on the one hand, wanting to give lip service and some genuine protections to campus free speech broadly construed, because there's a real concern about conservative speakers and the like not having enough protections for their expressive activities and speech activities on college campuses, and I think there's still interest in that, and that will drive some policymaking and executive branch activity. I think at this point, though, the larger set of concerns is conservatives being unhappy with the kind of speech that occurs on campus, and so looking for ways of restricting and suppressing speech of various sorts that they don't like on college campuses. And I suspect that will wind up being the dominant play. And so I suspect we are going to see a rough few years from the perspective of campus speech protections, including academic freedom protections, because there'll be a lot of pressure from the federal government, I think, to look for ways of restricting speech on campus that is dissatisfying to the incoming administration.
So Keith and I were both on the ground floor when we founded, we helped to found the Academic Freedom Alliance, which is a national organization that tries to protect academic freedom. And then at Harvard, I co-founded and was the co-president until recently of the Council on Academic Freedom at Harvard, which is like a group of faculty all over the university, again, who are interested in protecting academic freedom against encroachments by our universities and our schools. And I think that one of the really sobering lessons for me post October 7th has been that it turns out just, a lot of people who are interested in academic freedom and were like enthusiastically on board with this project of academic freedom and against the suppression of speech and against the suppression of expression. Well, it turned out like when suddenly they started encountering speech they really, really didn't like, the thing they really wanted to talk about more was how to suppress that speech. And so that's been a really interesting time for, I think, for all of us who have been committed to academic freedom since the beginning to, try to take stock of the fact that, like, I don't know if, Keith, if you have a different idea of, like, what percentage of the people who are really on board with this academic freedom project and all the organizations we're active in, like, in what way? I mean, is it like you're suggesting? Is it like you care about it when conservative voices are being squelched, or you care about it because you care about academic freedom, you don't like woke repression, right? That's what got you involved. You don't like woke repression. But then when there's like lots of woke expression, you're like, oh, do I really want there to be a lot of woke repression? Maybe the university should tamp down on that because it's considered incitement, or I think of it as dangerous, or I think of it as like intimidating, or all of these things, or discriminatory. So it's been, I don't know, it's been an interesting time. I really hope that the project of academic freedom doesn't kind of buckle under from the weight of these kinds of shifts based on where you stand in the political world. I really hope that people who are concerned about academic freedom, regardless of their views, can be, in a principled way, protective of people's freedom of speech, regardless of whether they really hate the speech. That in this organization that Keith and I are both leaders in, we have protected many academics whose speech I really have to hold my nose and do it. But that's what you're supposed to do, right? It's just, I think that's been difficult. And so we're gonna see the same thing happen, as Keith said, in the administration. It's all about free speech unless it's pro-Palestinian activists.
I've got one more question, and then I think we'll turn it over to the audience if that's all right. And this is about the present Supreme Court. It's 6-3 conservative supermajority, and in some ways the left's surprise at the legal agenda that the present court has pursued. And I think of a particular example coming from Dobbs in the abortion cases of fetal personhood. The legal idea of fetal personhood appearing in an Alabama State Supreme Court decision authored by a Dartmouth alum from the class of 1973, or concurrences in the Supreme Court's Dobbs decision. And the sort of ideological forces behind this have been well known for decades. My former professor at Princeton, your former colleague at Princeton, has mentored a generation of folks who have very publicly and sort of broadly advocated for this idea. And then when it started appearing, it seemed like everyone was sort of shocked. And I'm wondering, like, why you think that is?
Why are people shocked?
Like, it's not like Robbie was hiding for the last 30 years.
No, although I should note that I think the fetal personhood stuff it's a real position, and there are advocates, but I don't think it's gained tremendous traction yet, even on the right. And so I think we also shouldn't overplay how successful that's going to be in actually winning sufficient votes. But it is a real position that has its adherents, including adherents on the bench. And I think it's exactly right. We shouldn't be surprised that that's the case. Part of the problem is, I think, a feature of our polarized world generally, and it's also reflected in academia, is we are not very good about understanding the other side of the aisle generally, and that includes in the sort of academics thinking about the conservative legal movement, for example. And so I think a lot of academics on the left just don't have much of a handle on what the conservative legal movement actually looks like, what its internal currents are, what are real positions and what are not real positions, how deep are those positions, what motivates those positions. And so it makes it easy for people to be a little blindsided by some of the things then that emerge out of that movement, including now things that we see on the court. That's made more difficult by the fact that everything's in flux right now too, though. So it's not just the fact that it's hard to see the world on the other side and we have some blinders on, although I think those are real phenomena. But it's also the case that there's a lot of ideological flux now, including in the conservative legal movement and the conservative intellectual movement more generally. There are ideas on the table that were not on the table 10 years ago, for example, that are being seriously debated and have real influence in various ways. And so there's also an unpredictability there, and things can emerge very quickly and get on the agenda in ways that can, even those of us who were paying more attention and more immersed in that world, can sometimes be surprised by. So we should also recognize we're in a volatile intellectual environment, and that has consequences for courts also.
I think one way to think about this is kind of a 2x2 table where.
So you're really a political scientist
maybe
at heart.
I am. You've rubbed off on me, you all.
Right, yeah.
You know. Yeah. So if you think about it as 2x2, like you've got people who were pro-life, right? And so what they're motivated by is the idea that this is life, and maybe even a person, right? So that's all of what your energy is about saving human life. And then those who think that it's not a life, right? So those are two things. And then the other is just, people who think that Roe versus Wade was wrongly decided, regardless of whether it's human life or not. It was just wrongly decided because as a rule of law matter, as a legal matter, it was just wrongly reasoned. The legal logic was just not there. The Constitution does not contain a right to abortion. And so you could have that position even if you personally think that you would never have an abortion, or even if you personally think that women should have the right to choose, you might still think like the Supreme Court got it wrong with Roe versus Wade, right? So I think if you think about it that way, the fetal life position motivates some people, right? But a lot of the conservative legal movement has been motivated not by whether this is a life or not. They're called the pro-life movement, but it's a little bit of a misnomer for the large majority of legal conservatives who really got into this fight on the abortion rights issue. It really was the idea that Roe versus Wade was not a correctly reasoned, was essentially an unlawful type of exercise of judicial power, because there is no such thing as a right to abortion in the Constitution. The words due process, the concept of due process, does not contain that. And I can tell you that my stepdaughter, who read Roe versus Wade for the first time last year, when she was 17 years old, and she's totally pro-choice and all of that, she certainly didn't expect to read the decision and go, wow, this doesn't seem very logical. But she had that experience, despite being extremely pro-choice and thinking that women should have the right to choose. So I think, Keith, we're on the same page, that the conservative legal movement, what they were thinking about in terms of Roe versus Wade was the, sort of the rule of law issue, and trying to get that overturned so that the law would be, just fixed. Whereas, there may be some people, and maybe some overlap, where what they're thinking is we need to fight for the Supreme Court to be a certain way so that they can protect human life. And there certainly are many conservative lawyers, conservative legal movement lawyers, who have told me straight up, and I believe them, that if Congress tried to pass a sort of, a law that was, protecting human life, that certainly would be lawful from a constitutional perspective. But if the Supreme Court tried to declare there was a fetal right to life in the Constitution, that they would oppose that with as much fervor as they opposed the other, as they opposed Roe versus Wade. And there are some conservative legal movement types who really are like that.
Yeah, I'm not quite entirely sure how best to populate the cells in the 2x2. I mean, I think you're totally right, though. This is the right set of divisions, and I think it was easy for everyone to imagine that the conservative legal movement, so setting aside the larger conservative political movement or intellectual movement, the conservative legal movement specifically was all in the pro-life box, and a significant chunk of them were instead in an anti-Roe box,
Right.
and which is different. And whether that's the majority or not, I'm not entirely certain, but it's a big chunk at the very least. And so not terribly surprising, I think, as a consequence. And even if you're in the sort of the genuine pro-life box, it doesn't necessarily mean you're all in the fetal personhood category either. So you can probably subdivide that box as well, sort of as a sort of legal category and how people think about it. And so the fetal personhood component of that was a pretty small little subset, even within those that are pretty seriously pro-life in their core orientation and not just anti-Roe.
We've got about 10 to 15 minutes, so let's take a bunch of student questions. And Sonu, if you can see better from these bright lights, why don't you call on some students?
Well, okay, how about right here, student? I can call the one right in front of me. Yeah.
Hi, thank you so much for being here. So I mean, particularly for you having served on the presidential committee, I was wondering, do you see some of these recent rulings as either sort of occurring in bad faith or being sort of pushed on by sort of structural problems like pseudo-bribery or some of these things that, you know, the court has been accused of? And then would you make any changes to the Supreme Court, sort of structural changes based on that?
Yeah, so the first question about the scandals around the court, are they bad faith or so I think they're a combination, right? I mean, I think there's a bad faith weaponization of some of these scandals in order to make them bigger, in order to accomplish larger political ends, including reforming the court ultimately for larger political objectives. And there's some genuinely not good behavior on the part of some of the justices that really they should have not done, and they should clean up. And so there's real substance to some of that, and I think the substance has also been politicized, as you sort of expect in a political environment. As for reforms, I'm pretty skeptical, I think, of most of them. The one I remain somewhat sympathetic to is some idea of term limits. I think the term limits, though, to my mind, remains mostly a solution in search of a problem to solve. That mostly doesn't solve the problems people seem to mostly want it to solve. And it has its own real difficulties associated with it. And so I think the mechanics of how you design a term limit reform that doesn't create a lot of new problems is actually kind of hard to work out. And at the very least, I think any kind of term limits requires a constitutional amendment. So I think the statutory version is a constitutional non-starter.
Oh, please, yeah.
I actually have two questions. So the first one is regarding the state of antitrust law in the country currently, and the second one is regarding the Section 230 of the Communications Decency Act. So my first question is regarding the antitrust law. There's not been like a landmark antitrust case in the last 30 years. The last one was Microsoft in the 1990s, and Lina Khan is heading the FTC. And so recently this August, there actually was a case in the DC Circuit Court in which Google was kind of held liable for monopolizing power in the general search and general search text advertising domain, and this violates Section 2 of the Sherman Act. And so my question here is, how do you see the Trump administration handling antitrust issues in the future, specifically with regards to big tech? And the second question on Section 230 is also regarding that, people say, critics lament that this is kind of like a liability shield for companies, that it protects tech companies from, issues, liability issues, and they can use it to amplify certain voices and suppressing others. So my question also here is, given the fact that there's been a draft legislation proposed in a bipartisan effort this summer, how would you see the Trump administration, especially with regards to the controlled Senate and Congress, House of Representatives at the moment, how would they go about implementing a potential change to Section 230, and how would this differ from a potential Harris administration? Those are my questions. Thank you.
I don't know, do you feel like you have insights into this? I have to admit, I don't have a very firm grasp at all or strong predictions about how the Trump administration is likely to approach this, because I think on both of these issues, They're issues that divide the Republican coalition internally, and with more populist wing, I think, being often more supportive of these kinds of interventions than sort of the rest of the Republican Party. And I think it remains to be seen sort of who wins out within the Trump administration on that front. One of the weird features of Elon Musk now becoming buddy-buddy with Trump on this front is he probably is not going to be too enthusiastic about radical changes to 230, and that might make the Trump administration less inclined than they might otherwise have been, frankly, to be thinking about significant revisions of Section 230 in particular. So I don't know. I think it is one of those things that's sort of actively in play, and you can imagine the Trump administration going either way on both the antitrust issue relative to big tech and 230, and I don't have strong views about where it's likely to land.
Yeah, I mean, other than Lina Khan not being in charge anymore, and then therefore a different kind of approach coming from that very important position, I don't perceive these issues as ones on which Republicans feel like they were elected with a mandate to do something about it. And so I think if we were looking at a Harris presidency, we would be having real debates about both of these policies, because that these are some reformist impulses that have been important, I think, in the Democratic Party. I think in the Republican administration, there are just so many other issues that will take up so much airtime, and so I don't see either of these really going anywhere. I mean, it sounds like you are interested in something happening, so sorry.
It's okay. Sometimes you have to disappoint students,
Yeah.
right? So anyway, let's pick someone.
Also, be careful what you wish for on these kind of things, right? So
Someone on this side, maybe.
Actually, to your right, or to your left, actually, my right, down at the bend, down at the end.
Given that substantive due process was weakened in Dobbs, do you both see a future for a Ninth Amendment sort of revival, or maybe the use of the Privileges or Immunities Clause to protect rights that are not explicitly stated in the Constitution?
So I think Ninth Amendment's probably unlikely, but I actually do think the privileges and immunities may get some real play in the court. There's been, I think, a growing interest in the conservative legal movement to make that much more robust. A lot of scholarly interest in that. I think a lot of judges are sort of open to and inclined to, but it's sort of been reluctant to go down that path. And it wouldn't shock me if we found ourselves with some cases that developed it. I think the court's probably not going to want to open that door and run with it, but it wouldn't surprise me if you don't wind up with some jurisprudence, at least, trying to build on that.
So the Privileges and Immunities Clause is the path not taken. Like, we went down the due process path, and then we went pretty far with it, and then the Privileges and Immunities path was kind of closed off, because then we were on that path, and you just want to do the most you can and develop a body of case law. The Supreme Court, Justice Thomas has been really the person who's been consistently vocal about privileges and immunities, but that's not because he thinks we can get the same results by going down that path. He may, and others may think that the privileges and immunities was much more plausible legally as a reading of the Constitution, as a place to put certain rights, but I don't think it's because anyone who's interested in that alternative path is thinking, oh, we can just regain the right to abortion, or the right to same-sex marriage, or same-sex sexual conduct, or the right to contraceptives. It's not that. So when you're asking, like, is the privileges and immunities a potential avenue that could open? Yes. But does it mean that we are going to replicate all these rights by going down? No. Because I think that part of the interest stems from the fact that it's seen as more limited. And the Supreme Court's pronouncements on privileges and immunities, when they have existed, very little, has made it pretty clear that they're not going to be as capacious of an interpretive vessel for putting into it all kinds of rights that aren't like literally written down in there, right? The privileges and immunities of citizens of the United States, that's, you got to go look at what are the actual privileges and immunities of citizens of the United States. instead of being like, well, what does due process mean fundamentally? Like, what would it mean to be a human being if we didn't have such rights? You know, that's just overall so much more elastic. And privilege and immunity is a way of tamping down that elasticism.
Sony, you want to take the final question for yourself? I think we
No,
might
no,
be.
I will give it to a student. I'd rather, how about that?
A rare occurrence for a professor.
Hi,
Make
thanks
it
so
a
much
good
for
one
being
because
here.
we've had,
I'll try my best. I'll try my best. So, given that you're both kind of experts in this academic freedom, as you may or may not know, at Dartmouth, we had this really interesting dichotomy of having, just in terms of speed, one of the fastest police crackdowns on student protesters. At the same time, we had this like pretty expansive college-wide Dartmouth Dialogues initiative.
College-wide what?
Dartmouth Dialogues initiative, talking about like talking across difference. And so I was just wondering, like, in your view, what approach to student protest best honors the constitutional principles of free speech? And what piece of advice would you give to a university leader about how to handle these types of issues in the future?
Yeah, great.
See,
great
that's why I'm
question.
glad.
Yeah,
You're
yeah.
crazy. Wouldn't have come near that, right?
The provost sitting in the second row is really
Taking notes.
Yeah. So, should I go first?
Yeah,
or
sure.
you want
Go
to?
ahead.
Yeah. So glad you asked. Political protest has got to be part of our, any university's commitment to free speech and free expression. It's got to be. You know, it would be like if the university said no political protests are allowed at all. You know, I certainly would consider that to be highly repressive and inconsistent with the idea of academic freedom, free speech, and things like that. Some people might parse the difference between academic freedom and freedom of speech, and say that if you're committed to academic freedom, that may not include, like, the ability to, stage demonstrations or whatever. But I tend to think of them as bleeding into each other more than just being in these formal distinctive categories. So for me, that whole category of academic freedom of speech includes political protest. However, everything's got to be balanced against competing values, right? So I do not think that a university needs to say, political protest at the expense of disrupting the normal activities of a university, whether it's like being in a classroom learning or like, even being in public spaces. So disruption is like a concept that needs some defining. And so then we got to do the hard work to figure out what it means to disrupt. Does it disrupt if the protest is, say, silent? Does it disrupt if you have signs but you don't like make any noise? Is it disruptive if you stay outside of the classroom and you make some noise but not enough to like make the classroom like have to stop what they're doing? So these are all questions that we all need to debate. But for me, the line is disruption. And even with the debates you could have about it, if it disrupts the normal activities, like whether it's like the president's office getting their work done for the day, or whether it's a teacher getting through a lecture, or a lunchtime event that has to be like kind of stopped or stalled because of political protest, I don't think those things are things that the university needs to accommodate in order to fulfill its academic freedom and free speech commitment. So so I think that all of these things have to be considered in terms of competing interests, and some kind of compromise has to be reached. But I am troubled by what I am seeing all across the country at universities, that the idea that, because we're scared about congressional investigation, we're scared about education department investigation, we're scared about lawsuits, the idea that like the best response is to sort of overcorrect and just say, as a blanket matter, you can't ever use bullhorns ever, or you can't use chalk on property ever. You can't ever use light projections. You can't ever use banners. These are actual rules that Harvard University passed over this summer. I don't know, I shouldn't say passed, they were announced, that pretty much seemed to go through everything that pro-Palestinian protesters did all last year and just try to come up with a blanket rule that would cover it, even without thinking about how disruptive is it? Is it disruptive at all? Is it harassing? Is it intimidating? Like that, there was no analysis of that kind. So I'm not in favor of that.
Yeah, I mean, I would second all that. I think the only thing I would add to the issue about protest and expression is in addition to thinking about how do you balance the interest with, and disruptions, a perfectly fine guiding principle in thinking about the interests that need to be balanced there. The other concern is one of sort of even-handedness of application of these kinds of rules. And I think one real problem the universities have gotten themselves into over the last several years, and not just over the last year, is that they've been very inconsistent about how they've approached various kinds of speech activities on campus. And as a consequence of that kind of inconsistency and hypocrisy, it's made people very distrustful of platitudes about the importance of free speech on campus when it comes to particular speech that people find disturbing. And so I think universities need to be thinking very carefully about the policies they adopt and make sure that they are designed in ways that provide ample opportunities for expressive activities on campus that are consistent with the core functioning of the university, while also being a set of principles and rules that you can live with and are willing to apply in a consistent fashion across a range of expressive activities that might occur. The other thing, though, you referenced was this question of introducing sort of dialogue programs and the like, which a lot of universities have become increasingly interested in. And so while on the one hand, I think it's important universities do need to make space for expressive activities on campus, including various kinds of protest activities on campus. The very central thing that we do is an educational mission. And part of what we ought to be trying to do is then help educate students and members of the larger community on important issues. And among the ways of doing that is by trying to create venues that are not about shouting at each other on the quad or chanting slogans, but is really about engaging in serious discussion of hard ideas across some real differences and marshaling expertise to talk about important issues. And so I think universities have, to some degree, fallen out of the habit of doing some of what they could be doing of trying to bring to bear the expertise they have on issues of current events, for example, and other things where you can try to inform and elevate public discourse on campus and beyond campus on these issues. And so universities embarking on more programming that's designed precisely to do that, programming like this, I think is extraordinarily valuable, and universities ought to be investing in that. But there's no reason why that needs to be competing with how they approach other kinds of expressive activities on campus as well.
Let me elaborate a little bit, because there is a position that's like, I'm all for protest, but not when it crosses over into harassment, right? That's something you hear a lot, like what, and then the question is, well, what is harassment? Is it harassment because you experience it as harassing? Is it harassment because it seems to be negative about your identity? The thing is, we are here in part because, Keith, you're talking about the learning that goes on in the classrooms and those kinds of fora. Well, in the last, I would say 10 years, we've experienced an expansion of the concept of harassment, right? It started out more narrow, like that certain things like had to be severe, pervasive, that a reasonable person, that would make a reasonable person not able to access the benefits of it, all those sort of limits on what harassment was. They started to fall away in terms of how college, administrators and students and teachers started to say, oh, this person is uncomfortable. That's kind of like harassment, and so I should probably not do that. And so we get to a point now where lots of things are considered harassing. And so, of course, when people are protesting about a really controversial issue, the side that doesn't like that protest says and experiences it as harassing. And I think this is a moment for us, and I've kind of been saying it for a long time, maybe 10 years. We need to recalibrate what we consider harassing, because it does have this very importantly negative, chilling effect on the range of expression and the ideas and the learning and the exchange, the dialogue, all of that. It's harder for that to happen when we have such an expansive idea of what is harassing or intimidating behavior.
Guys, this has been extraordinary. Please join me in thanking our guests for informing and elevating our conversation.